Stare decisis. As we know, the common law is the root of American law. Stare decisis is Latin for let the decision stand, and it's a centuries-old legal concept handed down from the common law of England. Imagine stare decisis works like this. Whenever parties to a case appeared before a judge or jury, they would present certain facts. And based on the particular facts, the judge or jury would make a decision. These decisions, or opinions, were based on facts presented to the court. And then these decisions were written down, bound together in books, and read by other judges in nearby regions. Sometimes the published decisions from, say, Judge Anderson in one county in Oklahoma would help the decision-making of Judge Bartlett in another county in Oklahoma. Suppose, for example, that Judge Anderson wrote a decision called the Wandering Cow. That case involved a cow with a known tendency to wander out of its pasture and get lost, and sometimes do damage. The decision was written and published and read by Judge Bartlett in a neighboring county. Now Judge Bartlett has a similar case in his own court. Farmer Joshua's cow wandered onto Farmer James's pasture, causing damage to James's crops. Judge Bartlett may use Judge Anderson's decision, the Wandering Cow, as a guide in his own court. But now suppose that the case of the Wandering Cow is appealed to the Supreme Court of Oklahoma. However the court decides, the decision of James versus Joshua will become binding precedent on all lower courts. So that, in a nutshell, is stare decisis. A higher court's decisions are binding on lower courts. Stare decisis helps courts be more efficient and stable because having precedent saves time and creates predictable legal outcomes. However, keep in mind that stare decisis is for the judicial branch. It can be overruled by a later decision of the United States Supreme Court, or perhaps by the legislative branch with a constitutional amendment, or even a new congressional law.